Blessed day, everyone. The course that we will be discussing today is Introduction to Philippine Criminal Justice System. It is one of the professional courses as stipulated under the CMO5 series of 2018 for the program Bachelor of Science in Criminology. For the disclaimer, all information and pictures shown on these slides are for general education purposes only. I have no intention to claim nor to own it, so credits to all authors and owners. This discussion is not for advertisement, but this discussion was made in order to help the students taking up this course. Again, this is not for advertisement. This is a discussion that will give bridge for those students taking up this course to understand and to grasp easily about the topics included herein. This course deals with the study of formal and informal components of the criminal justice system of the Philippines. It covers the respective mandates, processes, and interrelations in the administration of criminal justice and other forms of justice system. This description also accord with the course description released by the CHED. So here is the course outlines of our today's discussion. Who is a criminal? Definition of crime, classification of crime. So at the end of the discussion, the students will have to define and explain the meaning of criminal, explain the meaning of crime, and explain and distinguish the classifications of crime. So this is our course intended learning outcomes for today's discussion. So let us proceed first to determine and to identify who is a criminal. A criminal is a person convicted of a crime by a final judgment made by competent court. In order to understand more about criminal, let us know first these terms and preference. When a person was arrested by the law enforcers, they are still called suspect. Or while the arrested person is in the law enforcement stage, the person is called suspect. Regardless, they were being caught in the act, or when the law enforcers so clearly that the person whom they arrested is the person who committed the crime, the person who was arrested can still be called suspect. And when the person now is filed in the prosecution, while the prosecutor is determining the probable cause, the person is called respondent. And when the complaint is filed in court, the person arrested is already called accused, who will now undergo the due process of law. So when a person, or when the accused received the final judgment, he is already a criminal who will serve the imposable sentence imposed by the competent court. So once the convicted or the criminal serve his or her sentence, let's say for example, the imposable penalty is 20 years. Upon serving the 20 years, right then and there, the person will go back to the community. Once that person will go back to the community, he's already called ex-convict, or some may call a graduate of penal institution. However, the term respondent may also refer to a person charged with administrative case. It must be stressed further that the term accused may be used as a noun and as a verb. As a noun, it refers to a person charged with a criminal case before the court. Then, if as a verb, it refers to the past tense of accuse. The term accuse is a verb synonymous with the word sue. So, in short, a criminal is one who committed the crime. A person who committed the crime because that person was found guilty. And when a person found guilty by virtue of verdict in final judgment made by the court, that person is already called criminal. Not unless when that accused was acquitted or the case was dismissed, he is no longer, or she is no longer called accused or even accused. It could be termed still as person or innocent person because he was or she was not found guilty thereof. Okay, again, when a person was arrested or under the custody or in the it is in the law enforcement stage, the person is called suspect, and in the prosecution stage, he or she is called respondent. And once the probable cause was established, the case was filed in court, then the person is called accused. A person who thereby charged with a crime. Then once the person, or when the accused receive a final judgment, he is already or she is already called criminal or convicted accused. Okay, so I hope that is clear to you. Next is, let us define crime. Crime is an act or omission punishable by law, or it may also define this way: a crime is an act or omission punishable by law, forbidding or commanding it. You have also to remember that crime is a generic term that embraces any violation of the revised penal code, special penal laws, and municipal or city ordinances. To better understand what is meant by crime, you have to remember this legal maxim, nullum crimen, nulla poena sine lege. in English translation, there is no crime when there is no law punishing it. So when you committed an act which is not defined by law, you did not violate any law. Remember the case of Hayden Ko. He recorded 6 videos. However, the act committed by Hayden Ko was not yet defined by any laws. Thus, what happened? Hayden Ko was acquitted, meaning he did not violate any laws. Until such time, the legislatures made the law that penalizes any persons who committed the same act made by Hayden Ko and other related acts defined by this law, which is the Republic Act 9995, which is also known as Anti-Photo and Video Voyeurism Act of 2009. Same thing also what happened to the person who the I Love You virus, Mr. Onil de Guzman. There was no law punishing his act. His act affects other computers from different countries. However, the Philippines has the jurisdiction over Mr. Onil de Guzman. Now, this act was not yet defined by the law, so he was acquitted. Until such time, the legislature created the law on cybercrime, which is the Republic Act 10175, which is also known as Cybercrime Prevention Act of 2012. Sometimes they say the one who created the law on Republic Act 9995 is Hayden Ko, and the one who created the law on Republic Act 10175 is Mr. Onil de Guzman. Now, don't put in your mind that you will also think about those acts that are not yet defined by law. But again, we are surrounded by laws. So, those laws penalizing or prohibiting such acts, when one committed this act defined by these laws, they need to face laws. And the better that we have right now is we have the due process of law. We have the rights of the accused. When a person is charged with a criminal offense, so that person shall be subjected for due process. That there must be presentation of evidence, and we have the rights of the accused that he is or she is presumed to be innocent until he or she is proven guilty. Next is the classification of crime. We have the according to the law of punishing it. First is the felony, and then the second is the offense. Felony is the crime punishable under the revised penal code, and those acts punishable by the special penal laws are called offense. So let us distinguish these two. Crimes under the revised penal code are called felonies, though it is not wrong to call felonies as offenses. On the other hand, crimes penalized by special penal laws are termed as offenses, but they cannot be called interchangeably as felonies. So what are those examples of felonies under the revised penal code? Murder, homicide, infanticide. And what are those offenses under the special penal laws? Let's say, for example, illegal possession of firearm, possessing illegal drugs. Such special penal laws are those Republic Act, yung naririnig yung Republic 9165. We have also the Republic Act 9262. Those are examples of special penal laws. According to presence or absence of intent, there are two: intentional crime and culpable crime. Let us again define crime. Crime, it is an act or omission punishable by law. Act refers to dolo, that requires with intent. And omission refers to culpa, that speaks about culpable crime. Intentional crime speaks about the person with the intent to do such act. It is the state of mind accompanying an act. Let's say, for example, I want to kill B. And using my firearm, I was able to kill B. So, that intent to kill B and accompanied by the act of killing him using your firearm, that is already an intent. Intent, it does not refer to mere will, for will pertains to act, while intent concerns the result of act. It is not about the will, no matter how you wanted to kill B, but there is no act or visible act, you are not violator, or you did not violate any laws. Then culpable crime speaks about negligence. That indicates the deficiency or perception, failure to pay proper attention and to use diligence in foreseeing the injury or damage impending to be caused. When a person thinks about himself that he is a good and a skilled shooter, linagay niya yung barrel, yung trigger guard niya, linagay niya sa index finger, and then pinaikot-ikot niya sa daliri niya, accidentally shots one person beside him. So you don't have the intention to kill or even to injure someone, but because of your negligence, you are still liable. Negligence will not exempt you from any criminal act, from any loss. You are still liable. Because you know in fact that the weapon is a very dangerous. Yet you try to think about yourself as if you are a good shooter, but in fact you are not. Okay, so intentional, there is the intent followed by an act. There is a visible act. Ginawa mo kung ano yung nasa isip mo, na kung saan yung iniisip mo ay labag sa batas. And when we say culpable crime, These are acts. Yung kakulangan ng skills mo or failure to pay at proper attention, katulad ng paggamit ng baril by means of could be accident. Okay? Yan yung under ng culpable crime. So, one, intentional crime, there is the intent to do act. And you know that act is punishable by law. But yet, you insisted to pursued to commit it. While culpable crime, a person has no intention to do such act, punishable by law. It was accidentally, it was made unintentionally by reason of negligence. Under the classification of felonies, according to gravity, we have grave, less grave, and light felonies. I will not talk much about these terms because it may produce a clog on your mind. I may somehow discuss this as we go on with our discussion. Because this talks about those imprisonment, the effect, and what would be the terms of imprisonment. Then, according to impact to the society, crime mala INSE and crime mala prohibita. Crime mala INSE is a crime or an act that is inherently immoral. While crime mala prohibita, it is prohibited by the statute. What are those examples of crime mala INSE? Murder, homicide, arson, rape. These are acts that are actually not socially accepted or violated the norms of the society. Kahit na sino talagang pangit yung perception sa taong pumatay ng gahasa. While when the example of crime mala prohibita is the illegal possession of firearm. Jaywalking, though it is not a evil itself, but because it is forbidden and prohibited by the law, they are felonies. They are offenses. Mala INSE is the intent governs, while prohibita, the only inquiry is, okay, has the law been violated? Okay, that is the distinction between these two. Again, mala INSE, it covers the intents that are governs. Intent governs. While prohibita, you need to know is whether or not the person violated a law. So, mala INSE refers generally to felonies defined and penalized by the revised penal code. Yung revised penal code na pinag-uusapan natin is we are referring to the book 1 and then the book 2. When the acts are inherently immoral, they are mala INSE, even if punished by the special penal laws. Mala prohibita, there are crime in the RPC or the revised penal code which were originally defined and penalized by special penal laws. Among them are possession and use of opium, malversation, brigandage, and libel. Okay, this may somehow this might be some of the terms or crimes mentioned may be uh, new to you. Okay? But then, yung crime mala INSE, it is evil in itself. Okay? While crime mala prohibita, since it is being prohibited, becomes offense. Becomes an offense. Let us define these two. Formal felonies and material felonies. Formal felonies, those which are always consummated. Because the offender cannot perform all the acts necessary for the execution without consummating the offense. A good example is the physical injury. Let us presume A was not able to hit B using his knife. There is no evidence to show that the act or the crime committed by the person is less or serious physical injury, because there is no evident injury inflicted to B. So this act, for example, this example or the physical injury requires consummated. While the material felonies that have various stages of execution that could be either attempted, frustrated, or consummated. But there are those which do not admit frustrated stage, like rape, theft, arson. And to all, I will further discuss about these topics that will be posted on our Facebook group. So stay tuned. This is only a preliminary or overview of our discussion. Then I will ask questions pertaining about our today's lesson. Please read in advance. Then if you have any clarifications or questions, raise it during our synchronous class. So, thank you to everyone. Magandang buhay. Maraming salamat. God bless to everyone.